Hi, I'm John Cannon with Cannon Associates, your fierce advocates for families facing military divorce. In today's video, I'm going to run down the 6 most important things for you to keep in mind when you or a loved one is facing a military divorce. There are over 100,000 service members and families in the state of Oklahoma, from Tinker Air Force Base to Fort Sill to Vance Air Force Base to the munitions plants and all the other installations, reservists and guard members across our state. We are heavy in that population. As a field grade officer myself and judge advocate in the Oklahoma National Guard, I see these issues week in and week out across our state. It's important to keep in mind the specific issues that relate to you when considering division and military interest, as well as military divorce in our state courts. The first important consideration in your military divorce is jurisdiction, or where your divorce may take place. Under Oklahoma law and federal rules, there's only 3 states that you should be subjected to divorce in. First, your state of domicile, or the state in which you've shown an intent to permanently reside. 2, your state of residency, or where you primarily live with your family. And 3, the state in which you are stationed or where you are currently serving military orders. It's important to keep in mind that under Oklahoma law, you must be in a state for 6 months before you may be subjected to divorce in that jurisdiction. The second important consideration in a military divorce in Oklahoma is service of process, or finding the individual in your case. If you're the non-service member spouse, you must serve the service member spouse and notify them you're seeking a divorce before they may be required to answer. Oklahoma law has something called a default divorce, where you file your petition, you serve the other party, and they fail to respond, you may be granted a divorce by default. However, there are special protections in place under Oklahoma law and federal laws concerning service members being subjected to a default divorce. Recently, in 2019, the Oklahoma Supreme Court decided Kohler versus Chambers, which gave great detail about the court's consideration of proper service and jurisdiction as it relates to service members. Please feel free to read my Oklahoma Bar Journal article that discusses in detail the issue of service member process in Oklahoma family divorces. The third important consideration in military divorce relates to child support and alimony, or the income of the service member. Most individuals that have employment have 1, maybe 2 sources of income. However, service members can have multiple forms of income. They can have their base pay, they can have upward adjustments for location pay, they can have a BAH or a basic housing allowance, they can have a BAS that relates to a food allowance, they can be provided additional orders. There's also bonuses for retention or re-signing with the military. If you are married to a service member that's a reservist or a guardsman, then they will have their drill pay or their monthly income from the military, in addition to annual training orders, additional active duty operational support orders, or multiple forms of income that may be provided to a service member. It's important that you identify these sources of income and ensure that the proper numbers are used to calculate child support and support alimony. One of the resources in order to assist you with this is by obtaining an LES that documents the income for a service member. The fourth important consideration for military divorce is the issue of relocation. Most people's service is transitory, meaning that they will be in one state for a period of time and then relocate somewhere else. Unless the person is a National Guardsman, most service members will be stationed in a state for a period of time and then relocate to another base, duty, or installation. It's important to consider the issue of relocation or its inevitability when you're drafting the orders of custody and visitation. As if you know this issue is coming, there are protections you can put in place as the service member to protect your rights when you move, or as the non-service member to protect your access to children if the service member leaves the state. The fifth important consideration in a military divorce is specifically the issue of visitation or time with your children. If you're the service member, there's a real possibility that you may be deployed, that you may go to a different installation for training or school or some other obligation. And if you're in the Guard, you may be out of state for annual training, for a national emergency, or being deployed abroad. It's important that you take consideration of these inevitable issues of being out of the state for a period of time when you're drafting and protecting your interest in the visitation orders. As the non-service member spouse, it's important to consider that these things are inevitable as well, so that you may draft provisions in the custody plan that protect your interest in seeing your children and protecting your time with your children. Finally, as it relates to the issue of visitation with service members, it's important to keep in mind that you can lay out a catch-all or a right of first refusal or a way to delegate your visitation to another family member. It's important that you memorialize these interests, these issues in the decree and order itself, or it may be lost down the road. Sixth, and most importantly to many, is the issue of division of military benefits, including retirement. The thrift savings plan is something unique to the service, and it is similar to a 401k. There's the issue of military retirement and the rules that apply to whether you as the service member spouse are entitled and what you must do to protect those interests. There are veterans benefits to take into account. There are the issues of healthcare or TRICARE that must be considered, and how or when you become eligible as a service member spouse to that, as well as access to the base or a ID card to allow you onto military installations. Although Oklahoma law deals with the issue of marital property and division of retirement accounts, Oklahoma law does not trump federal regulations and rules as they relate to division of these interests. If you have a divorce decree that drafts a division of military retirement that is not accepted by DFAS, it will be denied. If you are seeking divorce against a service member or a service member of your spouse, it is vital that you contact and retain an experienced, fierce advocate for military divorce to assist you in protecting your rights, not only under Oklahoma law, but federal regulations as well. I hope this video on the top 6 things to keep in mind when facing a military divorce has been helpful to you or your loved ones. However, this is only the tip of the iceberg when it comes to the issues that are unique to military divorce in Oklahoma. If you have more questions or concerns, please visit our website or call us for a free confidential case evaluation. It is so important that you not only obtain experienced family law counsel, but experienced military family law counsel. We're fierce advocates for families facing military divorce, and we stand ready to fight for you and answer your questions today.